Case 33. Deterra versus America West Airlines. We find ourselves here at the U.S. District Court. Facts. As of August 7, 1999, plaintiff was wheelchair-bound due to a degenerative neuromuscular disorder which rendered him a paraplegic. Together with his brother, Daniel Deterra, and sister-in-law, Catherine Deterra, plaintiff had reservations to travel on an America West flight to Boston, Massachusetts, scheduled to depart from Las Vegas, Nevada, at approximately 11:30 p.m. on August 7, 1999. When plaintiff entered the ticket line at the Las Vegas airport on August 7, 1999, to check in for his flight, plaintiff waited in line in his wheelchair for over an hour. He was not advanced to the front of the ticket line by America West, as had occurred in Boston. Plaintiff arrived at the gate for boarding his flight at least 35 minutes before the flight's scheduled departure. At that time, the boarding of first-class passengers from the terminal through the jet bridge, the tunnel-like structure leading from the terminal to the aircraft, had already begun. Plaintiff attempted to communicate with the America West gate agents after they refused to stop the line to allow plaintiff to board. He tried to tell the gate agents that he had to board first because it would be too difficult to board him with all the other passengers on the plane, but they ignored him, would not answer him, and would not look directly at him. Instead of talking to him, they looked over him and talked to his brother and sister-in-law. When plaintiff's brother Daniel asked an America West agent named Jay to allow plaintiff to go to the front of the line and board ahead of the other passengers, Jay responded that they would need to wait until after the other passengers had boarded. According to plaintiff's brother Daniel, when he and his wife and the plaintiff went to the counter in the gate area, they were told, "We've already started boarding the people. It'll have to be later. It'll have to be done at the end." Deterra was not initiating any conversation with the airline personnel. Plaintiff and or his relatives disagreed with America West's response. Catherine Deterra claims that she asked to speak to a supervisor, was told by an America West gate agent named Robert that there was no supervisor available, and he gave her a telephone number to contact. She claims that she was told by the woman she spoke to at that number that the woman was dismayed at what was happening, but that there was no one available to resolve the problem due to the late hour. After it appeared that the other passengers had entered the jet bridge to board, Daniel Deterra addressed the America West employee who was standing in the gate area nearby and who had told him they would have to wait, saying, pardon the expression, "Are you fucking assholes ready to board him now?" Daniel Deterra admits that he was very upset and might have been mad when he made this remark. He admits that he said it a little louder than normal and in a perturbed voice. Wayne DeMello, a friend traveling with the Deterras, recalls that when the group arrived at the gate to board the flight, other passengers were already boarding through the jet bridge, and he heard one of the America West agents tell Daniel Deterra that they would have to wait and board last. He recalls that Daniel Deterra was loud and swore, and that DeMello told Daniel he wasn't supposed to be loud and told him, "You can't say that here." He told Daniel Deterra to calm down because there was no need for him to be screaming. Plaintiff and Daniel Deterra both admit that if Daniel Deterra had not acted in that manner, plaintiff, his brother and sister-in-law, could have boarded their original flight after the other passengers had boarded. According to plaintiff, the America West agents indicated that Daniel Deterra's words were too forceful, and the plaintiff, his relatives, and the two friends with them would not be allowed to board the flight. Plaintiff's brother immediately apologized to both gate agents, Jay and Robert, for his remarks. Robert stated that he understood Daniel Deterra's frustration regarding the boarding situation. After general boarding had been completed, the gate agents advised plaintiff that he and his sister-in-law, Catherine, would be permitted to board the flight, but that plaintiff's brother, Daniel, would not be permitted to board that flight. Believing that he needed the assistance of his brother, Daniel, plaintiff chose not to take the flight. All three, plaintiff, Daniel Deterra, and Catherine, were rebooked on the next flight at 12:40 p.m., and they took that flight, arriving in Boston about 3 hours later than they would have had they boarded the original flight. So what's the issue in front of the court? Whether plaintiff was denied a reasonable accommodation within the meaning of the ACAA only on account of the following. Number 1, because airline agents talked over the plaintiff directly to plaintiff's brother Daniel. Number 2, because airline agents treated plaintiff in a humiliating and derogatory fashion by referring to him on account of his handicap as an it. And because the airline did not have a complaint resolution officer present when the incident at the boarding area arose. What was the court's holding? This court found and concluded that plaintiff cannot, based on the undisputed material facts, make out a triable claim under the ACAA. Defendant's motion for summary judgment was allowed, and judgment entered against plaintiff for all claims set forth in the complaint and in favor of the defendant. Let's look into some of the reasoning. Let's first look at what the Air Carrier Access Act, the ACAA, prohibits. Discrimination against handicapped individuals in general. In providing air transportation, an air carrier, including any foreign air carrier, may not discriminate against an otherwise qualified individual on the following grounds. Number 1, the individual has a physical or mental impairment that substantially limits one or more major life activities. Number 2, the individual has a record of such an impairment. Number 3, the individual is regarded as having such an impairment. Beyond the plain words of the statute, there is little legislative history surrounding the enactment of the ACAA, at least in terms of defining its scope. One court, however, has appropriately interpreted the ACAA as follows. The ACAA prohibits air carriers from discriminating against an individual because they have or are regarded as having a disability. The regulations promulgated in connection with the ACAA explain that the Act requires air carriers to, number 1, provide services and benefits without discrimination on the basis of disability, and number 2, to provide disabled individuals with certain services, equipment, or assistance. In other words, all persons are entitled to be treated equally, but qualified handicapped individuals are further entitled to certain services. Although the ACAA is otherwise silent as to what is and what is not discriminatory, Section 382.7 of Title 14 of the CFRs does provide the appropriate framework. Those regulations provide: a carrier shall not, directly or through contractual licensing or other arrangements, 1. discriminate against any otherwise qualified individual with a disability by reason of such disability in the provision of air transportation, 2. require an individual with a disability to accept special services, including but not limited to pre-boarding, not requested by the passenger. 3. Exclude a qualified individual with a disability from or deny the person the benefit of any air transportation or related services that are available to other persons, even if there are separate or different services available for individuals with a disability, except when specifically permitted by another section of this part. Or 4. Take any action adverse to an individual because of the individual's assertion, on his or her own behalf, or through or behalf of others, of rights protected by this part or the ACAA. If an indirect air carrier provides facilities or services for passengers that are covered for other carriers by sections 382.21 through 382.55, the indirect air carrier shall do so in a manner consistent with those sections. And C, carriers shall, in addition to meeting the other requirements of this part, modify policies, practices, and facilities as needed to ensure non-discrimination consistent with the standards of Section 504 of the Rehabilitation Act, as amended. Carriers are not required to make modifications that would constitute an undue burden or would fundamentally alter their program. In addition to these general prohibitions, there are a series of specific Title 14 CFRs circumscribing that which is discriminatory, relating to, among other things, aircraft accessibility, a prohibition against refusal of transportation, a prohibition against requiring advance notice of travel by a handicapped person, a prohibition against requiring, with certain special exceptions, a handicapped person from traveling with his or her own attendant, seating assignments, seating accommodation, provision of certain services and equipment like wheelchairs, boarding assistance on small and large aircrafts, none of which includes pre-boarding, assistance in stowage of personal equipment, treatment of mobility aids and assistive devices, passenger information, accommodations for those with hearing impairments, security screening, prohibiting the refusal to provide transportation to those with communicable diseases, except where health and safety of others would be endangered, prohibiting the requirement that handicapped persons have medical certificates, certain miscellaneous provisions, all of which relate to service and in-flight accommodations, and prohibiting the charging of a fee to accommodate handicapped persons.